it's weird in that marriage does and it doesn't impact those documents. It impacts them because, well, there's now someone that you need to take care of and provide for, and under Michigan law, it is technically illegal to disinherit your spouse. So in order to make sure that your spouse is provided for, you need to update your estate plan documents to plan around that or to include him or her in there. And with wills and trusts, it's not automatically read in where the new spouse is automatically the primary beneficiary. No, it's up to you to take the affirmative steps in order to make that actually happen. So yes, your spouse can inherit most, if not all, of your assets should you pass away without a will. When a person dies without a will or anything in place, what happens is that Michigan has a set of laws referred to as intestacy laws, where a person dies without any estate plan documents to their name. Typically, the spouse would receive, and it all depends on if the person who passed away had any living children, any living parents. There are different scenarios that Michigan law contemplates, but essentially the surviving spouse would take roughly between the first 100 and I believe 175,000 adjusted for inflation of the estate, and then half of the remaining balance, and sometimes it's like 3/4 or a quarter, depending on what the family structure is. But essentially, he or she, the surviving spouse, would get the lion's share, and depending on what assets, if there are any left over, then it could go to potentially their kids, the deceased person kids who aren't kids of the surviving spouse, or the parents of the decedent. You can reach me in my office by calling us up or at nick@dellenbuschryanlaw.com.